Okay, this video, I'm just going to do a Q&A and see what falls out based on a lot of comments I receive or statements people are making, and they're generally making it from not yet comprehending what law is and are stuck within the realm of equity only, and then interpreting equity through the lens of equity without having the foundational principles of law to then have a better comprehension of what equity is to make such comments or statements. So, first question, let's get right at it. Question, what are the principal laws that establish the fundamentals of English law? Answer, there are three: natural, common, and equity. Natural law is essentially those rights existing in each as a creation of nature. They are non-transferable, equal to all people of sound mind. Blackstone rights. By the absolute rights of individuals, we mean those which are so in their primary and strictest sense, such as would belong to their persons merely in a state of nature, and which every man is entitled to enjoy whether out of society or in it. But with regard to the absolute duties which man is bound to perform considered as a mere individual, it is not to be expected that any human municipal laws should at all explain or enforce them. Common law is a form of a relative right, so it's not absolute. Essentially, it recognizes the now to the passage of life, whereby an estate in common law either terminates at death or is fully conveyed to another through the action of livery-accession or escheat, or through bargain and sale after the statute of uses. It is the foundation of the strict settlement of an estate in land and governs the original legal title notice as the beginning land interest in English law. There are three types of estates in common law, which are limitations. They are the fee, the life, or the entail. It does not affect future interest or those estates created and administered through perpetuity instruments like governments, corporations, races, and church. Equity law is a notice of a secondary relative right to the use of land as an estate interest. It circumvents the common law mainly because this was its original purpose, of lords who held a legal title subject to the common law who wanted to control land other than those rights offered under the common law strict rules. The church and Jews were notice of corporations and a race, so were excluded from the right to hold an estate in common law. Ecclesiastical courts evolved into equity law. The equitable use of land later became known as the origin of the trust instrument. Equity law governs the trust and notices a beneficial right to land and equitable title, namely, whereas the legal title is held in trust as a permanent res, as it is notice of the capital money. Question: what are the three main jurisdictions in English law? Answer: dominion, territory, and citizen. Dominion, in reference to the absolute right of an individual, is not considered in common law or equity immediately, as it affects an individual right, whereas both common law and equity affect rights to an estate in land that then establishes an obligation through a determinable power and duty. Monarchy is notice of the title which holds the right to an estate in land for and on behalf of the class termed people. This agreement is merely a confidence imposed upon the monarchy through operation of law, not an act of parties. Territory is subject to those rights granted through contract between the monarchy, the holder of the common law right to land, and the government, who has agreed to administrate over the second level of use to land subject to the law of equity. This is through an act of parties to which the people are not immediately privy to or have an immediate interest in. These are patents generating proprietary interests, which represent a responsibility to account for the waste while in the use of the land that is subject to a trust for sale. Citizens hold the third level of use to land as a quasi-trustee and or custodian. They purchase rights to property under a trust for sale scheme that began in 1925. Citizenship affects an obligation to take care of the land used through purchase under a trust for sale scheme, which is regulated under the rules of equity. Equity overreaches the common law of the territory if there is a conflict. The agreement is managed through the legislation, which is then administered through their own territorial courts. Question: what establishes the principal law for courts to act? Answer: basically, the courts look to the agreement. Is the agreement a matter of common law or equity, whereas this is determined by establishing the subject matter. Before the concept of subject matter becomes an issue, the court first must determine the parties through the vehicle of status. Both status and subject matter arrive at what laws are available to offer remedy within a defined jurisdiction. Question: isn't the Pope the supreme ruler over the monarchy? Answer: which one? Meaning there is a chattel that sits on the throne for all the sightseers to gawk at, to which holds the common law right to an estate in land. And then there is the illegal personage, the crown, which is subject to the duties and powers of a constitutional monarchy. The latter contracts with the government. The Pope is in alignment to those estates that are subject to equity, not common law. And so this relationship between the monarchy and the church is confined to estates of perpetuity use, not life, fee, or entail estates used as limitations in common law. The value is derived from controlling the fruits of the land, not from holding the land itself as capital money. The Pope is the public head of the Christian corporation. It's the world predominantly that is directly subject to equity law, thereby the rules that govern the fictions created within equity law. Question: isn't the monarchy an impostor and or the coronation was illegal, etc., etc.? Answer: no matter if you sit a monkey upon a throne, they are just symbols that bring animation to the title. This assists in reifying the abstract to give the title life. The title holds all the power, in the same way the legal title is not the physical document itself, but the rules of engagement that give effect to the title deed. The monarchy title of England is secured within its power and a common law settlement, and so the entirety of English law. Question: the courts are all fraudulent. They receive their power and duty through admiralty law and do not care to protect human rights. Answer: well, that's more of a statement, not really a question. What is the agreement, I ask, as the courts only look to the agreement that the parties are subject to. If you are relegated to admiralty law, for instance, means it is not relegated by the English common law courts, but rather equity. Thereby, you are presumed to be in an agreement under the device of government. Human rights are equal to all those who are of the same status and rights to the subject matter under a trust for sale, as assumed owners. So, if the court is adjudicating over an equitable issue, they would affect the human rights according to the life of a perpetuity instrument, not immediately a natural life, as this court of equity must form its determinations through the powers it has over the agreements allowed within equity, so it does not commingle with the life represented in the common law or of natural law. There is no fraud unless one commands the correct status and so has the right to the subject matter controlled under English common law, and then the court, who can hear the matter, ignores it and reverts to the laws of equity, thereby forcing one into an agreement concerning future interest in land. Then by the court discounting this right, your inherent right held in common law, namely, will naturally make all other laws void and so constitute all common and equity laws to be fraudulent. Otherwise, fraud can only happen within the same law and subject matter. Question. The one who carries the most might wins and unlawfully enforces their will upon me as an individual. Again, more of a statement. Answer. Have you corrected your own status so as to command the attention of a formal court of law, who then can adjudicate over the estate held in common law? Have yet to hear of one individual doing this, not one in my 20 years of research. Know any? Think of it another way. What gives a fiction realized in equity the power over a life, such as government, which is notice of a group, so a fiction used by law? For instance, can a corporation lose a leg, suffer natural life damage, or decompose into matter so as to feed nature? The answer is obvious, since it is merely a concept, an idea brought into existence through the objectification and disobjectification techniques. Essentially, the magic of reifying the abstract. They are governed through equity, not immediately through English common law. Question, which again is more of a statement. The Bible is the law. That is all you need. Answer. What law does the Bible have a right to enforce, considering that the Judeo God and the Christian God created thereafter is not with any right to dominion nor of the subject matter held in common law? If you can prove to me in law that a perpetuity instrument has the same rights as a natural individual in common law initially, then all history would be wrong. Jews governed banking, the entry into sin essentially, which is in reality holding debt instead of holding the credit, the capital money annexed to the land itself, noticed in common law. Question. I can use scripture in court and have won. Another statement. Answer. Won what? What did you win? What court level are you in whereby legislation is a secular institution and so religion is not a matter of state? Courts not held in English common law are equity courts, thereby evidence of use to a land through a perpetuity instrument, a fiction, and so identifying a singular beneficial right that then becomes one within a class of beneficiaries that become classed as citizens. Enfranchisement of a government interest through their own actions, whom are essentially quasi-trustees without compensation from the trustees. Question. I have a loyal title to my property because I have the original patent. Another statement. Answer. A patent created under government is subject to the laws of a trust. They are notice of an equitable interest by the very fact that government holds a secondary interest to land. The monarchy holds the first as fideicommissium to the right of land held in trust for the people. The people hold a superior title right through a right to the common law legal title. Consider government. Sorry, we'll just have to ignore that. Here, let me just see if I can. Oh, it's from Kentucky. Oh, yeah, you know that's going to be. Consider government is first a fiction that holds a patent. For instance, the government formed to govern the territory called Canada, made first through purchase of Hudson Bay Company's patent, which is evidence of a grant to the use of land. So what is the highest patent one can hold as an interest in land? If, like I just said, if it's a secondary interest, and that patent that you may say that you have now is first secured through a territorial right, such as USA or Canada as such. What patent would that be? Question. Another statement. All you write and talk about is word salad. If you were more simple in your explanation, then we could actually learn something. Okay? Answer. I suspect some days my delivery can be a bit wordy. On the other hand, I do no service to the reader or listener if I tell them to read the law themselves, but do not use the same words that they do. Can you read and comprehend case law markers and lawmakers and historians like Cook or Bracton or the commentaries of Blackstone? If not, then it may be the limitations of your own vocabulary rather than the subject matter and distortion rather than the subject matter, which is a distortion in your own mind. I still have to look up legal definitions of words daily, in fact. Seriously, I do it every day. That is how I came to better comprehend where my true power exists. But I have to first comprehend what are the words used in law so that when I read the law, I can not only now comprehend what they're saying, but now can also express it in their own language. Question/statement. Can you just give me a document that I can read and next use to notify the court of my status and my interest? Well, that was actually a question. Answer. Do you know how to enforce your standing without commingling law or stand in front of a civil court judge and discuss status, thus jurisdiction, no matter the questions thereafter asked? This is your absolute freedom and those of your lineage. It is not just available to everyone, since most are not ready to hold or not ready or hold an honor to be afforded the right to law. This is an individual journey, the power realized through self-proximity. It is enforced through the ability to stand in truth, although I have given some subtle hints within my videos, and so if you are with the eyes to see and ears to hear, then you will arrive at these same foundational truths that are tenable, and as such will become easy discussed without bringing in the history law to do it. But if after reading or listening to my, or maybe not listening to my videos or my comments, or from you not listen or reading any case law or history of law, when a court, if you just use a simple document, could you completely understand what that document means? In most cases, no. I have seen many people use documents and you ask them, well, what does this mean? What does that mean? They don't know. So no, a document is not going to do you any good. Your full power is coming from your own understanding, your own self-proximity, so that when you're asked, no matter who you're asked by, you are now imbibed with that power that no one can shake. Okay? Statement question. Dave, you are wrong. Equity is the spirit of the law. It dances within my heart, and it states wherever there's a conflict or variance between the rules of equity and the rules of the common law with reference to the same subject matter, the rules of equity shall prevail. So equity is more prevail. Sort of accentuated a certain part, and we're going to go into that. Answer. Equity is more powerful when what? When the common law and equity share the same subject matter? First and foremost, law came before equity, so the creation can never be greater than the creator. In the same manner, government can never be greater than the monarchy, and the monarchy can never be greater than the rules which govern titles as opposed to a natural life. A maxim of law states this: ignorance of the law is no excuse to be in a violation of the law. Are you in violation of the English law when you are using equitable rules that regulate territorial right over land? No, because they are not the same subject matter. And so if the common law being considered against equity means they must be of the same subject matter. So the common law considered under specified territorial jurisdiction. Equity is subject to a trust. The original common law is not subject to a trust. Why? There is two land acts created in 1925. One not subject to a trust and the other subject to a trust, evidencing two completely different subject matters. Governments have no right to things common law because they are perpetuity instruments created to govern over that secondary interest under a trust. So, if you're saying equity prevails and equity is all powerful, well, it can only have the power over the common law interest that is of the same subject matter. I hope I put that to rest. Question. Let's see if it comes out as a statement. As the beneficiary, the Cestui trust namely, I can access my account, get a black credit card, and set off debts in the public. Answer. Can you? Well then, you will need to study and learn the duties and powers offered to the status of a beneficiary. I am not interested in this type of remedy. Here's why. To be recognized as a beneficiary means you are then in agreement to equity law and a title and next the rules of a trust. For a trust to be constituted, it can be determined through proof that the legal title is held in someone else, a trustee namely, to which then affords you the equitable title subject to an act of reversion. This means you will always be subject to the agreement and thus not only controlled by English law, but can never possess the legal title. Thereby, your own action then is against the trustee, not the thing held in res, the common law title. And as such, you will remain at the highest right in equity that allows you to become an executor of this title only. The system is moving all property titles in the hands of trustees, thereby removing the need for the quasi-trustees. What will this mean to those acting as beneficiaries if the trustees are now in control through the creation of these new titles? The right of a trust. I'm not interested in splitting my power over land with some other who holds the power of the legal title, thereby be subject to those rules. I am an individual of nature, not a group and not a fiction. So, just to sum that up, if you are saying that, that you can do all these things, means you are at the whim of the trust instrument. Thereby, there still is another layer above you. Thereby, you can never possess legal title, is what I am arriving at. Question. Statement. You said you are above the law. No one is above the law. Answer. English law creates rules over rights to estates in land. It does not create rules over people unless they are holding an agreement that is recognized in English law. Man is of nature first. His laws are the laws of nature, not natural law, as natural law just identifies those rights that man is endowed with, the right of dominion and free will. Laws of nature are non-agreement. English law is notice of agreements. So if you hold the land outside of English law, so now hold land subject to the laws of nature, then are you logically above the law? Question. I'm in court. They enforce me into their jurisdiction. Why? Answer. To be 100% responsible is not less than 100%. It is up to each individual to correct their status through learning what is law. So arrives at not commingling laws or holds any property in their jurisdiction. A man simply cannot serve two masters, so either nature or fictions. It is simply a jurisdictional issue originally. Once in their jurisdiction, then you have to establish issues that are relevant to those laws available to the citizen, such as the name charged in a court subject to a territory. Are you the name's owner? Here, I'm going to give you a little bit of information to then contemplate. In fact, if you're caught within their jurisdiction, means then what? You are assumed to be acting in right of an agreement because a court only looks to the agreement. So, I'll continue. Does the name, I ended up with, are you the name's owner? Does it represent you or do you represent it? Meaning, what status are you acting as when you are not the owner? A trustee position, perhaps? And if a trustee, do you have the right to be compensated once the court recognizes this truth? I hear people using fee schedules to deter them from proceeding. This is placing the cart before the horse, in my honest opinion, as one has to act according to the rules and not inadvertently create bars by not first getting determined your status according to the name called. This is primary, whereby once determined, meaning you do not move off topic until it is, or if after repeating the same need for determination the court continues, then the fee schedule is introduced as compensation for the job as acting trustee. Did they accept notice through notice and then action? This is not legal advice, and so I only affect the law first, so not to be subject to the jurisdiction of equity in the first place. Also, come prepared to deal with proof that you are the fiduciary for the name. Look to case law for the test that the court uses to assist in determination of whether you are acting in the role of fiduciary. Prove the test. Then next bring this to the court as an entry point. So you already win before you even enter. What is the adage for lawyers that lawyers use before they enter the court and before they ask any questions? Know the answer to the question before you ask it. So the same applies here. Complete the tests that identify what constitute a fiduciary duty. If you pass that test, do I need to say more? So, I'm now going to ask the question to you, the listener. What documents are created at birth when considering that English law creates rules of action over land only? Please take 1 second to like or dislike if you don't like what I've said, whatever. Okay? And or the same amount of time to subscribe. Share it with others, and until I finalize my trust through proper access of the court, which I'm doing right now, any donation is greatly appreciated. Details are added below. And I will end. God bless you all.